Kicking things off, a very warm welcome, everybody in attendance on this chilly morning, at least in Mumbai, to this legal health check workshop, capacity building session on the Foreign Contribution Regulation Act, organized in partnership with the respected Nitish Desai Associates for the RISE World Summit 2024. It's a pleasure to be here, and we look forward to your keen participation, your keen attention, and any questions that you may have through the course of this workshop. Next, Yashji. A quick but important disclaimer that must be stated before we carry on. This presentation, unfortunately, does not constitute legal advice. Its contents should most certainly not be relied upon as such. If you should require pro bono legal consultation to address any issues that we may identify together through this session, please feel free to reach out to Junita or myself to access TrustLaw, where you may be able to submit a request for connection with for a professional consultation. Next, Yashji. A brief introduction to our panel here today. Mr. Rahul Rishi leads the blended finance and social sector practice of the research and strategy-driven international law firm Nitish Desai Associates. An alumnus of the prestigious Tata Institute of Social Sciences, Bombay, and Gujarat National Law University, Rahul is a member of the Bar Council of Jharkhand, an integral part of NDA over the past 11 years. He has extensive experience in advising clients on social impact bonds, impact investing, foreign contribution laws, CSR, and cross-border philanthropies. He is a part of Startup and Climate Practice Group at the firm and actively contributes to policy advocacy in terms of streamlining the regulatory framework for such verticals. And as part of his policy advocacy efforts, he has been part of the committee set up by the Maharashtra Chief Minister's Office to reform the Bombay Public Trust Act. A warm welcome to Mr. Rahul, and thank you for your kind presence here today. We have Emmanuel, Ms. Emmanuel Maripara, who joined the Thomson Reuters Foundation in September 2022 as a programs officer in Asia. Emmanuel is responsible for managing relationships with TrustLaw's network of social enterprises and NGOs in the Asia Pacific and connects them with legal professionals to promote legal pro bono practice in the region. We welcome Emmanuel as well. We have Ms. Junita Brito-Menon, who is the legal program manager for Asia, overseeing and managing TrustLaw's program in the region. Through her role, she supports her team in facilitating pro bono legal assistance between lawyers, social enterprises, and NGOs in an advisory or research capacity. She brings over 8 years' experience working for the rights of victims of human trafficking and commercial sexual exploitation, and has supported the International Justice Mission and other anti-trafficking activities in India. Welcome, Junita. And last but not least, we have myself. I am the legal officer for Asia with TrustLaw from October 2023, and I manage the legal network and help in the connection of social enterprises and NGOs with legal help in the Asia Pacific region. I work along with the Asia team, as mentioned, to expand TrustLaw's network of legal professionals, law firms, and in-house counsel to ensure that organizations are connected with legal aid in the region. It's a pleasure to be here, and I'm sure the sentiment is shared by my other speakers, and we are looking forward to a productive session. Yashji? Before we dive in once again, we have a standard housekeeping rule that must be stated. Please enter your questions in the chat as we go along so that we may note the same and address them either on a rolling basis or towards the Q&A session at the end of the workshop. I do realize that Pico's wonderful platform leaves no scope for any unmutes by the audience, so we will begin with the agenda. I will take us through a brief introduction to the Thomson Reuters Foundation and introduce the TrustLaw service. We will then have the legal health check that will be led by Mr. Emmanuel. Mr. Rahul will then take over on the FCRA explainer and will be able to tackle any questions that may arise. And obviously, and actually, we will wrap up with the Q&A session towards the end of the workshop. Yashji? Let's dive right in and allow me to begin with some background. Launched more than 10 years ago, the Thomson Reuters Foundation is the corporate foundation of the Thomson Reuters Group, which is a global news and information services company. At the Foundation, we have three thematic focus areas in which we use the combined power of journalism and the law to advance media freedom, foster more inclusive economies, and promote human rights. Accurate and balanced news coverage is critical to informing public opinion, revealing previously undocumented stories, exposing abuses of power, and holding authority to account. The law is also fundamental to establishing and protecting the rights of individuals and to upholding free, fair, and informed societies. Our unique experience and expertise combines and leverages over 100 years of journalistic excellence with the burgeoning marriage between technology and the law to drive freedom and development of media bodies, working to make businesses and enterprises sustainable and inclusive, and to promote human rights. We believe there is a symbiotic relationship between our three focus areas, and one cannot thrive independently of the others. Yashji? As crucial pillars of any free, fair, and informed society, media outlets are currently facing unprecedented economic and technological challenges, and the vital role that journalists play is increasingly under attack around the world. Rising government control of the news industry, disruption of traditional business models, and rapid changes in how people consume news, growing competition as well from alternative media, the proliferation of misinformation and disinformation, and the resulting erosion of public trust in news sources undermines accurate and impartial journalism. Part of our service includes a global editorial team of over 500 journalists and 300 freelancers covering unreported stories from women's rights, LGBTQ rights, poverty, climate change, social innovation, and modern slavery. Thomson Reuters Foundation is committed to fostering the highest standard of journalism worldwide, and we run a series of training and grants programs led by world-class experts, which combines hands-on experience and opportunities for the international distribution of news outputs. Likewise, there is an increasing recognition that the mainstream economic model is generating a deepening divide and hurting our planet. Growing inequality, the climate crisis, the need for a just transition, and the impact of data and technology on people are among the biggest challenges of our time. The global economy is now 5 times larger than it was 50 years ago, but inequality is rising, and more people are excluded than ever. We employ a blend of journalistic expertise, as mentioned, to promote the development of the S in ESG agenda, the advancement of social entrepreneurship, and to support a just transition. While human rights underpins all of what we do, our work is grounded in Thomson Reuters' trust principles of independence, integrity, and freedom from bias. We work to shape public discourse about new and ongoing human rights issues through our own news coverage, as well as our journalism training, legal support, and research for NGOs influencing policy change. Trust Conference, last but not the least, is our flagship annual event and leading human rights forum. Held in London each year, we bring together over 600 delegates from across sectors in the globe. So you may stay tuned for further information on this year's edition of the Trust Conference. Last but not least, we also have TrustLaw. Yashji?
Free and accurate information is increasingly being silenced. The inequality gap is widening, and the climate emergency is one of the greatest threats the world has ever faced. Globally, legal professionals are stepping up to support individuals and communities at the front lines of these challenges. In 2022, lawyers dedicated more than 3.5 million hours of free legal support to charities, nonprofits, and social enterprises, supporting them to deliver change where it's needed most.
When we first started kind of exploring this zero upfront cost model, almost everyone we knew in the industry told us that it would be impossible.
In Argentina, our data law dates back from the year 2000. It used to be an innovative law, but now it no longer protects what it intended to protect.
The Committee to Protect Journalists was hearing constantly from journalists who were finding themselves in an unprecedented and incredibly dangerous situation.
At TrustLaw, a key part of our work is connecting leading law firms with high-impact organizations working across 3 areas. Media freedom, like guidance on rights and legal remedies for journalists to shield them from unjust legal attacks. Inclusive economies, like legal research to lay the foundations for the UK's Equal Pay Bill. And human rights, like legal advice to support the release of 24,000 pretrial detainees in India. Through work like this, Pro Bono continues to drive positive change for organizations and communities around the world.
This support in terms of building and developing new products has been extremely critical in allowing us to succeed as a company.
We were very worried about the personal data law in Argentina. The pro bono legal assistance was very useful because we could access to high quality comparative legal analysis.
We were able to create a resource outlining the rules around the movement of personal protective equipment. It has been instrumental in ensuring that journalists who are traveling to cover the war in Ukraine can better prepare for what is already an incredibly dangerous assignment.
At TrustLaw, we are proud to support the lawyers, social enterprises, and nonprofits whose dedication changes lives every day.
Thank you, Yashji. We are a small but driven and diverse team spread across the world, all working with the common aim of furthering pro bono globally. Headquartered in London with the rest of the foundation, we have team members in New York, Buenos Aires, Madrid, Nairobi, Manila, and Mumbai. Yashji? These figures all point to the efficacy and breadth of TrustLaw service. We have clocked in over $242 million in pro bono hours from the time of TrustLaw's beginning, and around $29 million of pro bono hours clocked in 2023 alone. We are proud to have facilitated close to 10,000 connections, with over 6,100 member organizations receiving aid from over 1,000 law firms and legal professionals spread across the globe. Our growth is a testament to the quality and impact of the services that we have been fortunate to provide and continue to strive to make accessible to the broadest base possible. Yashji? We must stress that our services are provided at no cost to member organizations with no membership, processing, or application fees. Free legal advice and assistance enables our members to streamline operations, expand into new countries, and scale their impact, all while remaining mindful and protected under the myriads of laws and regulations that can vary across jurisdictions. This helps them focus on their mission without spending valuable resources on their legal needs. We facilitate advisory services across intellectual property and technology, such as the trademark and advice and assistance that was provided for the name and logo for social enterprise that produces solar-powered irrigation systems for small plot farmers. Across corporate law, we've drafted an organizational resilience policy, child protection policies that ensures business continuity in the case of an unforeseen event. In one case for an NGO, that was a no-cost, non-medical essential services for pediatric cancer patients. We advise across commercial contracts where we've helped review a template donor agreement, particularly on conditions for donors to comply with, for an NGO that creates future leaders to help eliminate education inequality. In the banking and finance realm, we've also helped provide finance and regulatory advice for a nonprofit that promotes the theory and practice of permaculture worldwide. Across employment, we've also helped review and amend a template consultancy and services agreement for a social enterprise that designs and implements solutions to reduce food waste and cost through a preventive program that includes technology and workshops. So we provide support for organizations in their day-to-day legal needs. This could include establishing new legal entities domestically or across international jurisdictions. We can help provide advice on hiring, employee and volunteer management, contractors or other commercial partnerships. We could also help you draft corporate, commercial, finance-related contracts and agreements, including data protection privacy policies, and various terms and condition policies. We would also help you facilitate advice on trademarks, copyright, or patents under the local or international regimes. Yashi. TrustLaw also helps NGOs and social enterprises access world-class legal research for free to develop resources backed by qualitative and quantitative data that can be further used as tools for advocacy to lead path-breaking legal and policy reforms. These research projects can cover up to 10 jurisdictions and can focus on various topics ranging from modern slavery, climate and resilience, social innovation, refugee rights, media freedom, LGBTQ rights, and human rights for either single or multiple jurisdictions. We have also produced various legal guides on operational issues, for example, on the best legal structures for social enterprises, or guides on impact investing and regulations governing crowdfunding, and know your rights guides for journalists in volatile conditions. With the permission of our member organizations, we also facilitate the design and publishing of the research that we help do to reach the widest possible audience, immediately scaling up its impact and efficacy across jurisdictions and domains. Yashi? This slide contains some of the examples of the research that we have facilitated, including an ASEAN Social Enterprise Structuring Guide in 2019, a guide to better understand which legal structure is the best for your social enterprise, comparative research on the rights and protection of domestic workers, a blended finance guide for India, a research on child-friendly provisions for children in contact with the law. We've also helped facilitate a research for fact sheets on internet shutdowns. And we've also been honored to have collaborated with Nishit Desai to develop an impact investing guide for India as well. I now invite Emmanuel to take us through the TrustLaw service. Emmanuel, over to you.
Great. Thank you so much, Sean. Hello, everyone. Good afternoon from the Philippines. I hope that you find the first part of our presentation relevant and useful. Now, moving on, Sean already gave you a walkthrough on the types of assistance that you can request to TrustLaw. So here's a quick list on who can access our free membership. Next slide, please. Yeah, so here are our eligibility criteria. First, your organization must be incorporated and registered in compliance with local requirements or authorities. Second, you must be working towards a social mission that addresses either social, humanitarian, or environmental challenges. Third, your organization must clearly express their social objectives, including the impact that you are trying to achieve, whom you are helping with, and how you plan to do this. Fourth in our criteria is that you must be non-discriminatory, you are apolitical and non-proselytizing. Fifth is that you have to submit at least one annual report on your activities and impact. You also have to prove to us that you have been operating for at least 1 year. Next is that you have to be able to demonstrate your financial sustainability for the next 12 months of being a member of TrustLaw. So you can present to us either your agreement with your funders or with your investors. And then lastly, for social enterprises, you must demonstrate a commitment to reinvest a majority of 51% of your profits into your social mission, either on your website or your governing documents. Next slide, please. Now, here are the legal issues that we cannot offer support for. So, unfortunately, we cannot advocate on behalf of any individual or any organization. Second is that we cannot take requests on behalf of a third-party organization. So, only members of TrustLaw can submit a request via the online portal. That's why we are encouraging all of you to apply for TrustLaw membership for free and for a lifetime. Third is that we do not take assistance for litigation, disputes, and disagreements. For litigation, what we can offer you as support is a legal research that you can use to strengthen your case. And then we also do not support for visa applications or any advice related to work permits or visas for your employees, either locally or internationally. We also do not provide support for administrative or tax issues that are not related to any legal issues. And then urgent assistance, because we do have a 1 month processing period before we can connect you to a law firm. And then lastly is translation of documents to any different language, because English is our primary language at TrustLaw. Next slide, please. Now, one of the best things about TrustLaw, aside from it being for free and for a lifetime, is that the process of submitting a request is very easy and very user-friendly. So here's how it works. So once you're already a member of TrustLaw, you can use your login details to access the online portal. You have to click the new request and then fill in the request form. And then once that's ready, click submit and then book a call with our team according to your availability and to your time zone. Again, TrustLaw is global, so we definitely make sure that we have a team member in every time zone. Next is that you have to attend your online call with a TrustLaw lawyer. So this is a crucial part of the process because this is important for us to further understand your request before we share it with our member legal firm. Now, once our team have scoped your request and you agree on the definition of your request, we will now post that on our online portal where all of our legal members have access and can submit an offer of assistance. Again, your request will be kept confidential, so this will not be shared publicly. 6 is that if we receive an offer of assistance from a law firm, we will share it with you and then you have the freedom to choose if you want to work with that law firm or if you want TrustLaw to keep looking for another law firm until we successfully connect you with a law firm. And then once you accept an offer, we will introduce you via email and then you'll have the flexibility to coordinate with them directly. So TrustLaw will then gather feedback periodically and we are always available to support in case an issue arises during the process. Next slide, please. Now, moving on to the legal health check. So the legal health check will help you assess your organization's legal needs and connects you with our team for necessary pro bono assistance. May I please request everyone to scan this QR code and then answer the survey. Could everyone please give me a thumbs up if you, can you please go back? Thank you. Could I please request everyone to give me a reaction, either any of the reactions available if you are already on the survey? Because I will help you go through the survey. All right, perfect. Now, the legal health check has 7 categories. So as you can see on the form, the first category is governance. So all of the questions here are answerable by yes or no. The first question is, do you know and understand the standards of corporate governance that your organization is required to meet? The second question is, are you confident that your governing documents are up to date and accurately reflect your social mission, activities, and the way decisions are made by your directors and trustees? Again, please answer these questions by yes or no. So coming up from these questions, if you want to update your governing documents or your articles of associations, then TrustLaw can definitely support you on that. Right? Now we can move on to corporate structuring and tax. So this is the second category. So this has 5 questions. Do you want to expand your organization or set up a new one? Do you want to set up a trading arm? Or are you confident that you are using the right legal structure for your organization? Are you aware of the tax benefits to which your organization is entitled? And then lastly, do you know whether you are required to register for VAT or to pay for corporation tax? Now, it is very important to comply with tax implications to avoid any problems that can be a hurdle to the operation of your organization. The next category for the legal health check is the finance and regulatory compliance. Now, many organizations, including non-government organizations and social enterprises, receives grants, investments, and do fundraising. This can also be globally. Now, you should have a proper documentation and agreement to avoid any conflict since this involves money. For finance and regulatory compliance, we have here the questions: do you fundraise? Do you transfer money between countries or do you receive money from abroad? Do you take out loans or raise finance through shares? Are you seeking investment from any institutional or individual investors? And then lastly, do you work in a highly regulatory field? The next category, again, is very important: commercial contracts and real estates. Do you supply or distribute products or services? Do you collaborate with other organizations on joint projects? I'm pretty sure everyone here collaborates with other organizations, similar to what we are doing now with the organizer of the event. Do you understand your contracts and the key clauses to look out for in case there is a dispute? And then do you rent or lease the property that you are currently using? The next category is intellectual property. I know that we take pride of our brand, our logo, and the name of our organization. That's why you have to ensure that your intellectual property is being protected. So do you have a brand, idea, invention, or any written work that you want to protect? Do you use a third-party intellectual property? Again, if your answer here is yes, then TrustLaw can help you with that through our pro bono assistance. Next, again, very important, is the data protection, privacy, and technology. I think we can all agree that technology, including social media, has become an essential component of running an organization, which is why you have to make sure that personal data and information that you are receiving or that you are gathering are being kept confidential. You should have a disclaimer and data policy in your website or in your organization documents. Now, the questions here are very simple. Do you collect, handle, or share the personal information of any individuals? Are your website terms and conditions up to date, and do they include any privacy policy? Do your employees understand the risks involved in using social media? And do you work with software or application developers? The last category is employment. Of course, an organization will not run without an employee. So kindly ensure that you have a human resource policy, you have a proper employment contract, and if you have volunteers, then make sure that you have a volunteer agreement or you have a volunteer contract as well. So do you understand your different legal obligations toward your employees, especially if you have employees from abroad? Do you have a human resource policies that will help employees understand your organization's internal policies and procedures? And do you have any concerns about your employees' contracts? And then lastly, for the legal health check, is the legal research. Again, as mentioned by Sean earlier, aside from the legal advisory, we also provide assistance on legal research. So if you have any rough idea or initial idea for a legal research that you think can contribute to your organization, please feel free to provide that information on the survey, and then our team will get back to you to schedule a call so that we can further discuss your request. Next slide, please. Sorry, before we go to the next slides, alright, I know we're all very excited for the next part of the session, but before we start to the next part of the event, can I please request everyone to complete the form? And if you have already completed the survey, please give me a thumbs up or a clap or any of the emoticons available. Now again, this survey will not be shared publicly and will be kept confidential. So only TrustLaw Asia team will have access to your answers. Great. I think everyone's very excited and ready now to the main highlight of our presentation. Can I please now go to the next slide? So I am so honored to call our next speaker, Mr. Rahul Rishi, who leads the blended finance and social sector practice of the research and strategy-driven international law firm, Nishit Desai Associate. Rahul is one of our most active and most supportive Trust Law members. He will be presenting about the Foreign Contribution Regulation Act 2010. Can we all please give a warm welcome to Rahul? Over to you now, Rahul. Thank you.
Thank you, everyone, and thanks in particular to the Thomson Reuters team for having me here to speak with our audience. And it's been a great experience. I have been associated with Thomson Reuters for past 1 decade now. I think more than a decade. Since I joined NDA, we've been working on some or the other projects with Thomson Reuters Foundation in the past. So I think it's been great working with them, and Thomson Reuters Foundation as an organization is the right kind of a platform that allows different stakeholders to interact with lawyers and other industry stakeholders as well. So in that sense, the initiatives that TRF is currently undertaking on FCRA is quite laudable, and I am very excited to interact with you all and to take you through the nuances on FCRA. Yes. Can we move on to the next slide, please? Next. Yes. So, when we look at FCRA, there are three essential pillars on which FCRA rests. One is the fundraising aspect. The second is the aspect of governance. And the third is the aspect of regulatory compliance. These are three essential elements that a non-profit operating, excuse me, I just have a little bad throat. These are three basic elements on which the entire FCRA ecosystem rests. Now, before we get into the detailed nuance of what FCRA Act is all about and what are recent challenges and issues that organizations have been facing, or the recent amendments that, I mean, the amendments are not recent per se, but sort of legislative changes that we have seen happening across FCRA. Before we go on to all of that, we would like to start with one basic premise, and I think a lot of us experts or industry stakeholders or even public in general, we fail to understand the real essence of what this act is all about. Let us not forget that this act has a progeny under an emergency era, and this act very much is a reflection of the emergency era law that was created back then in 1976, if I'm correct. Yes, 1976. Now, the context of FCRA back then was about political interference or alleged political interference, and ways through which the government could ensure that no foreign money could come into India to affect or to have any specific I would say economic or financial support being made to certain opposition members or to civil society organizations. And this typically is a template. Excuse me. This typically is a template that we see across democracies happening. For example, the recent case I would like to take is about Pakistan. Now, when this entire Imran Khan saga happened, there was a lot of hue and cry made that, there's a lot of foreign funding coming into NGOs, which are in cohorts with the opposition party of the day, and hence this is destabilizing the nation, and this is questioning the very sovereignty of the nation. So that's the broader, I would say, ideological, premise that one always has when one looks at a foreign contribution law in any context or in any geography per se, not just in the context of India, but across different geographies. So when we look at FCRA, what we must understand and acknowledge is that it is a security law. It is not a law which is there to facilitate or enable smooth functioning of foreign contributions coming into India. It's a law which was enacted during an emergency era. It was a law which was not built on rule of law principles. It was not a law which was per se intended to be democratic, right? And this law very much was, it was more of a political instrument than a legal instrument. So unless we do not acknowledge and understand the nature of the beast, it's very difficult for us to then also, look at FCRA from a practitioner's perspective, and then try to understand the nuances of it. So I think this is one premise which, I mean, even when we interact with a lot of our clients, and a lot of times we keep hearing that FCRA law has become very aggressive, or there are certain I would say, I mean, for the lack of a better term, certain clauses or certain parts of FCRA law has been weaponized, and we keep hearing all of those things. Now, I'm not saying that the law itself is not stringent, but what I'm saying is that the law was prima facie structured to be very stringent, for the reason that this law is seen by the government as a security law. It is not seen as a charitable law per se, right? So I think let us keep that premise in mind. Now, once this 76 law was enacted, a need was felt that the law should be revisited. And as there is a practice in India, and the saying as it goes that nobody can stop a bad idea from taking further shape. So we further reenacted the 1976 law and made it even more stringent. And again, the 2010 Act was made even more stringent, and the backdrop of it was, around that time this entire civil movement had started to happen in India, whether on the anti-corruption front or on the anti-nuclear power project installation front, and there were a lot of civil society movements happening across Indian geographies along different states. So I think the 2010 Act, which was reenacted, had imported most of the stringent measures of 1976 Act, and it made the 2010 Act even stricter in that sense. So I would say the 1976 Act, in comparison to the present Act, was a lot sober. As funny as it sounds, but yes, that is how the case was. So I think these are two basic premises, that for the government, and irrespective of which government dispensation we have, when the government looks at this law, the government would always look at this law from a security threat angle. When an NGO looks at this law, the NGO would always look at this law in terms of expecting, rule of law principles or administrative conveniences, or a law which should have been there to allow for smooth transition or smooth transfer of foreign contributions into India for the rightful reason. So I think these are two separate assumptions under which separate stakeholders operate, and this is the greatest, unfortunately the saddest irony that we have around FCRA. It's quite paradoxical to that sense, because whenever we speak to stakeholders, we get a different view. When we take up our case, when we take up cases or issues with the Ministry of Home Affairs to represent our clients, we get a very different view. So I think somewhere, the right hand is not talking to the left hand, and somewhere there's a huge disconnect. and that further gets escalated because of the fact that it's a political law. So depending on which political dispensation there is currently, you always have different pulls and pressures operating around FCRA, and that's the present state of affairs that we have around the FCRA regime. So I just wanted to lay out certain basic premises under which we should try to understand what the government does, why it does. I'm not trying to rationalize what it does, but I'm trying to put across a point as to what's their thinking behind what they do, and how do we perceive it as stakeholders on the other side of the aisle, right? Yeah. Next slide, please. Yes. So, I mean, I'm pretty sure that most of us would know about these basic fundraising norms that we have under FCRA, but I'll still repeat it for greater clarity. So under FCRA, there are two ways through which one can receive fund. One by way of a prior permission, and second by way of a full-time registration. Prior permission is allowed on an ad hoc basis, right? And it is mostly used, prior permission facilities mostly used by such non-profits who do not want to have a full-time registration, but at the same time they have a project specific donation which a donor is willing to provide, and they more often than not know where exactly would they want to be deploying their money. So in a scenario where an NGO does not have a 3 years of standing, but the NGO still wants to raise funds, right? And the NGO does not want to have a full-time registration, one can always approach the government, file an application for a prior permission application, under which the donor has to be identified, the project that you want to execute has to be identified, your area of deployment, your area of operation on the ground has to be identified, and you have to also tick certain boxes. For example, project should only be towards charitable, social, educational purposes. It should not be towards any sectarian movements, or it should not be only catering to a certain class of the society in that sense. And these are basic common elements that or boxes that you need to tick if you need to file for a prior permission application. The same conditionalities do also apply for a full-time registration. The only difference is that for a full-time registration, you need to have a certain number of standing before you are eligible to apply for a full-time registration. At the same time, via the 2020 amendment, the government has also now made it mandatory for NGOs to first attain a certain fiscal threshold before which they should be eligible to apply for a registration. So, for example, if you are an NGO and if you wish to file for a full-time registration 3 years after you have been you have been set up, then you cannot be expected to sit idle. The government expects you to at least have a certain financial threshold that you should achieve, and there has to be a certain, I would say, transactional strength that you should have before you should be eligible to file for an application, right? So I think if the numbers are correct, the minimum, I think it's 15 lakh or something, where you need to have a transaction of that amount within a period of 3 years. Now it could be seen both ways. One argument which I have heard people take is that, look, this is one way to ensure that most of the NGOs do not reach that fiscal threshold, and hence you would want them to remain outside of the FCRA purview. The counter side of the rebuttal to that argument is that, look, we wouldn't want situations where we simply set up an NGO and then it sits up for 3 years doing nothing. And then one fine morning we decide that, hey, look, we have to file for an application and then we should go for a full-time registration. So these are two conflicting views. But yes, if an NGO wishes to file for an FCRA application, and if that is something which is more of a future plan for the NGO should still ensure that they continue to be operational on the ground. And I say this for a reason that the on the ground operational presence is very much needed, because once you file an application under FCRA, there is a certain procedure that is being followed. And the procedure is that once an NGO files an application, there is a thorough IB investigation that happens on the background. I mean, they wouldn't investigate you per se the way they do with different agencies, but it's more of an informal investigation there, where they want to understand what are your operational presence on the ground all about, what activities are you involved in, are your activities political or apolitical, right? What specific affiliations do you have? Whether those affiliations would allow you to remain non-partisan, bipartisan, or would allow you to remain, biased towards a certain political ideology or a political party or a political formation. So these are few on-the-ground investigations that IB officials do. Then they prepare an internal note, which is then forwarded to the Ministry of Home Affairs, basis which they undertake an assessment and evaluate whether your application should be processed or should not be processed. Now, this entire process in itself, excuse me, is a little time consuming, and it could take anywhere between 6 to 8 months. We have seen instances where such applications have taken more than 2 years as well. And again, that process is a function of where do you as an NGO stand, which is to say that, for example, if I were an NGO that would work in the area of human rights, right? And if I were to be operational in the peripheral regions of India, which are geostrategically sensitive for India's interest, chances are quite high that the application process would take a lot longer for me to achieve the registration than what I would otherwise take if I were to be operative in places like Delhi or Kolkata or Bombay, right? So what we have to also understand is that the entire FCRA application, right, is a function of sectors or subsectors that you operate in, what sort of activities you carry out, and of late we have seen a certain, I would say, political filtering of what sort of NGOs can and cannot do certain types of activities, or what sort of NGOs should or should not be present in India. I think I'll come on to that aspect in later of my slides. but these are two basic application processes that we have under FCRA, which is one is the prior permission and the second is the registration. Yes. Next slide, please. Yes. So key definition, we have foreign contribution, foreign source, and foreign hospitality. Now, I think most of our readers, viewers would know about this, but I'll still repeat. Foreign contribution essentially is it means any donation, delivery, or transfer of any foreign article, security, or currency from a foreign source, whether you receive directly or indirectly. Now, there's a nuance in the definition of foreign contribution. The definition of foreign contribution clearly excludes any foreign inward remittances that are made by any foreign person or a foreign entity or a foreign source to an Indian NGO when such payments, when such remittances are made by way of payment or by way of a service payment. Now, let me give an example here. If I am an NGO which is based in the US, or forget about me being an NGO, if I'm a person in the US, I'm sitting on certain funds, and I want to use the funds to sponsor a research activity in India, right? Now, I could talk to an NGO in India which is an FCRA registered NGO, and there are two ways through which I can provide that money to the NGO. One, the NGO could take that money from me into its FCRA account, subject to the NGO having an FCRA, right? And the other way is where the NGO could provide services to me, where I call up the NGO and say, hey, I want a certain project survey to be done on a specific theme in, let's say, Madras, Chennai, on human rights or on any other theme for that matter. And I want you and I want the Indian NGO to provide me a detailed report of their findings. The moment the interaction is between two parties where there is an incidence of service that arise, right? And a payment is made by a foreign person, and a foreign person could be a foreign trust, a foreign foundation, a foreign tax exempt entity, or a foreign university, or a natural juridical person. It could be any of that. So when a payment is made to an NGO in India, right, then such payments are not considered to be foreign contribution because those are pure commercial payments. And under FCRA, definition of foreign contribution clearly excludes that any payments that are being made in India as against certain services that one renders, those payments should clearly be outside the purview of FCRA. Now that's the carve out that the Act has clearly created. However, there is also an additional nuance onto it. In a scenario, let us assume that the Indian NGO does not have an FCRA registration. Okay? In the absence of an FCRA registration, they would not be able to receive foreign contribution or raise funds from foreign donors. But the NGO thinks, hey, why don't I enter into a service agreement with an offshore donor? And the offshore donor then allows me to conduct certain field surveys on the ground. I prepare a report, I prepare a detailed report, and then I send it back to the foreign person. And because this entire interaction gives incidence to a service, a payment that comes to me should ideally then not be treated as a foreign contribution, and that should be permissible. Now, legally, that is absolutely allowed, and that is what the carve out under the FCRA Act has provided for. However, we have seen instances where such service payments have been seriously brought into question, right? So when we look at the definition of a foreign contribution and the exceptions that are provided under the definition with respect to certain payments not being a foreign contribution, we also have seen instances where the ministry has taken a view that, look, just because it is a service payment does not mean that you automatically fall under the exception route. You still will have to tell us what was the intent behind the service, whether the service was simply to skirt around FCRA or was that service more genuine and more transactional. So a lot of times our NGO clients also face this scrutiny from the government where they might be conducting a certain projects on the ground, or their entire work profile would be a mix of charitable as well as service oriented activities, and they would raise invoices from outside from offshore entities, and those transactions have also been looked very carefully into. uh, I would give you another example. In fact, a couple of years back, Amnesty, Greenpeace, and similarly other NGOs had also set up their wholly owned for-profit entities. And they thought that, hey, why don't we look into a hybrid structure where we set up a non-profit and a for-profit? And all for-profit related activities would then be carried out by my for-profit entities, and non-profit activities would be carried out by my non-profit institution. And that way I would be in a position to dehyphenate between my charitable as well as non-charitable activities, and that would allow me to take care of FCRA. Now that intent in itself is very good. There's no problem with that. However, the ministry argued that, look, the very fact that you had set up a hybrid structure where you felt the need to set up another for-profit entity to be engaging into providing services to parties outside of India in itself could be construed as something which you were not allowed to do directly, you have been trying to do indirectly. So the counter argument that the ministry took was that, look, why cannot I assume that if you were to set up a wholly owned for-profit subsidiary in India, and if that subsidiary were to provide services to parties outside of India in lieu of certain service fee, what if those service fee could otherwise have come through the foreign contribution route had you had FCRA registration in the first place? So we have reasons to believe that you are now trying to indirectly contravene FCRA provisions. Now, a couple of years back, we used to hear of these arguments basis certain transactions that did take place, and we always thought that, look, an exception is an exception, and more often than not the government would not go on to invoke such assumptions in such a stricter fashion. But of late, the frequency of such accusations, I wouldn't say accusations, the frequency of such assumptions have increased manifold. So this again is an advice to foundations that are here on the group listening to us. Exercise discretion and be a little careful about service invoicing that you undertake. Now, in a scenario where you are an FCRA registered entity and you enter into a service agreement with a foreign party, make sure that you tick the right boxes, and your services should both be in form and substance. It should not just be on paper to ensure that you get the monies to India while continuing to remain outside of the FCRA ecosystem. We have seen instances where NGOs having FCRA registrations have also entered into service agreements and have raised invoices and have received those funds into their domestic account and not into their FCRA account, which has been okay. But in certain circumstances, we have also, or in certain scenarios, we have also seen situations where FCRA registered non-profits have raised invoices to their foreign service recipients, and those specific transactions have been specifically looked into by the Ministry of Home Affairs. So we need to be very careful about whom we are going to engage, whom we are going to be engaging with, and whether that nature of interaction gives rise to service, and if it does, how do we navigate around that? I have no straight answer for our NGO folks here as to how do we navigate, but these are few recent trends that we have been seeing of late, and there is a high chance that these trends would continue to have a more vigorous nature. Yeah. Any doubts so far here, or any questions that we may have?
Participants, you're welcome to ask questions either through the chat, or you can unmute yourselves as well and share the questions that you have. I think someone has in the chat just shared their introduction. Thank you for doing that. But we would like to use the chat space or the Q&A space on the panel for you to add questions you may have for Rahul. But Rahul, it doesn't appear to be any questions right now, so you can go ahead.
Sure. So, yeah, sure. So I would also like to give another example. So last year we had a query coming from one of our major foundation clients, and the query was that, look, we want to enter into a service arrangement with one of our Indian donor, and the Indian donor had an FCI registration, but for some reason our client felt that they wanted to enter into a service contract because the nature of work that they expected the Indian NGO to carry out were a mix of charity as well as non-charitable activities. So they wanted us to help them understand whether such a service agreement would pass the litmus test under FCRA scrutiny. And so we went back, looked into case laws, we did our research, and we essentially found three basic thresholds that an NGO should always keep in mind. And these are the thresholds that MHA, which is the Ministry of Home Affairs, also has in mind when they look at certain transactions. One, if I enter into a service agreement, is me entering into a service agreement with a mala fide intent, where the entire assumption is that I want to defeat the FCRA route directly and hence I want to enter into a service agreement? Is the intent mala fide? Is the consideration extraneous, which is to say that is the transaction there for something else than what I have to show on paper, right? So if I do not have a mala fide intent, if my considerations are not extraneous in nature, right? And if the deployment of funds are for specific activities which do not intend to be political in nature, if the NGO meets these three criteria, I do not think the MHA would unnecessarily want to get into the very propriety of why did you enter into certain transactions. Now, these three considerations are largely applicable to NGOs that are that are largely perceived as apolitical. Now, nothing is apolitical. Personal is political is what a lot of people say. So it's very difficult to argue that you know I am an apolitical organization. I mean that's something which can only exist in vacuum, right? I don't buy that at all. But having said that, when one says that one needs to be apolitical, what it essentially means vis-a-vis the government is that, look, do not be overcritical of my thematic areas or my thematic ideologies. I think in plain and simple terms, this is what it means to indicate, right? Now, I think we have a question here. Sorry, hang on. Dear Rahul, we are looking for raising funds through a service agreement. We will be contacting TrustLaw with our specific questions post the workshop. Okay. Sorry. Yeah. Okay. So yes. So I think I have spoken enough on the service agreement component. I'll go on to the service source, foreign source definition now. So another important query, which I don't know why people still have this doubt, and we keep getting these queries on and off, and we have run enough hotlines on it, we have run enough updates on it, but this confusion continues to pester. Whether wholly owned subsidiaries of a foreign company would be considered as a foreign source in India or not. Let me, clear the air, and I'll give you an example to explain this. Hindustan Unilever is a wholly owned subsidiary of Unilever UK. Now, a couple of years back, if Hindustan Unilever India were to give a CSR contribution, then the recipient NGO who could receive such contributions would also be expected to have FCRA before they could receive it, for the simple reason that the definition of a foreign source back then clearly stated that if you as a parent entity had more than 50% of equity infusion into a subsidiary entity of yours, then the subsidiary entity would be considered as a foreign source. And hence, most of the wholly owned subsidiaries or most of the subsidiaries of foreign companies in India would automatically be treated as foreign source for the purposes of FCRA Act. And the moment you are a foreign source, you cannot possibly give that money to an NGO if the NGO did not have an FCRA registration, because foreign source is an important trigger for FCRA to take place in the first place, right? So a lot of NGOs would then, want to have FCRA registration before they could even receive CSR funding from them. Now, since the advent of CSR laws, a lot of the subsidiary companies also had a robust CSR budget and they wanted to provide CSR funding to these NGOs, but they could not do so because these NGOs did not have FCRA. Now, that position has significantly changed now. Wholly owned subsidiaries of a foreign company are no longer considered as foreign source for the purposes of FCRA, right? So if an Indian NGO wishes to receive CSR funding from subsidiary entities of foreign companies in India, they need not have FCRA registration to receive those funds. And I'm saying this repeatedly because we continue to get this query from our NGOs, from our NGO sector clients that, hey, look, we want to receive funds under CSR, but we do not have FCRA. What do we do? You do not need to worry. You do not need to have FCRA if you want to receive CSR funding from Indian companies. There is one exception, however. If you wish to receive CSR funding from banks that are foreign banks, for example, Citibank, Standard Chartered banks, right? Standard Chartered Bank, Citibank, HSBC, for example. Now, these are banks that are not incorporated in India. These are banks which are represented by their branch offices in India. So should you wish to raise CSR funds being an NGO, and if should you wish to get in touch with these foreign banks who have their branch offices in India, then you would need FCRA registration before you are allowed to receive those funds, because foreign banks offices in India are still considered as an extension of the foreign entity, and they do not have a separate legal entity presence in India. And hence, to that extent, whenever you approach a bank which are not Indian banks, more often than not, those banks would be considered as foreign source, and Indian NGOs would then need to have FCR registration, right? So if we have an Indian NGO who wants to receive funds from HSBC under their CSR route, as much as they would give you money under the CSR route under Section 135 of the Companies Act, you would still need to have FCR registration before you are eligible or allowed to receive those funds. So I just wanted to re-clarify that. Other than that, feel free to approach any companies who are subsidiaries and you do not get hit by FCR. That's completely out of the way, except for banks. Certain class of banks, rather. Yeah. Next slide, please. Yes. Persons prohibited from receiving foreign contribution. Yes. Now, this is an interesting amendment that had come in the year 2020, where persons who are prohibited from receiving foreign contribution, the definition of the persons who are prohibited has been expanded to include civil servants as well as public servants. Now, there was a specific context as to why they had amended this definition. I would not get into that. But from an NGO governance standpoint, I would like to give an example to state what it means. Now, if I am a citizen, if I'm a person who has been on the board of an NGO, and if I have been a public figure, right? Earlier, the FCRA Act had only covered civil servants and government servants, but now that has been extended to also include persons who have been on certain constitutional or statutory positions in the past and are now no longer holding those positions, but for the FCRA purposes, those persons would still be considered as persons ineligible to receive foreign contribution. A case in point. Let's say I have been a part of any particular government commission or a government board at some point of time, and those posts were largely constitutional posts. I would serve there for 5 years or 4 years or whatever that tenure looks like to be, and then I retire or I resign, and then I have my own NGO and I want to receive foreign contributions. There are high chances that the government would look at your past affiliations, and if they have reasons to believe that you fall under the definition of a public servant, then you would not be allowed to receive foreign contribution. Now, how would they define who is a public servant is again not very clear. It's ambiguous, and it's best left to the government to determine whether they feel comfortable allowing you to have those specific permissions or not. But yes, please keep in mind that if FCRA registered NGOs with board members having political affiliations, or if they have certain political ideologies, and if those affiliations or ideologies are very much out there in the open for others to see, and if that is not in agreement with the dispensation, with the agreement with the government of the day, then there are quite high chances that your FCRA entire application process or the approval process might get stuck in some bureaucratic maze. And we have, and I say this because we have seen such instances where FCRA triggers have been caused because of specific affiliations of certain board members of certain NGOs in the past. And I'm not saying this particularly in the context of Oxfam or Greenpeace or Amnesty. I mean, those were separate cases altogether because of a lot of discomfort that government has with certain big NGOs in general. But even otherwise, for such non-controversial NGOs as well, the modus operandi that the government follows or the agency under FCRA follows is that they look at your board members' composition. They then want to understand what your affiliations in the past had been. They would also want to understand what your current affiliations are. They would look at your social media profiles. They would look at your social media presence. They would look at what you post and do not post to ascertain what sort of political ideology you have. And taking all of those factors into account, they evaluate their assessment internally, and then they take a call whether you should be or should not be accorded an FCRA registration or not. This is what the modus operandi currently is. For good, bad, or ugly, I'm not here to say that, but that is how it is. That is how it is. So, for members who are listening here and who happen to be board members, if you are in love with Twitter, if you are in love with social media, and if you are in love with typing things within 100 characters, please exercise certain discretions. Yeah. Because there's a clear mandate that officials have been given to thoroughly go through social media profiles to understand what sort of tweets are made, what sort of comments are provided, and that is one way to probably ascertain, as unscientific as it may be, what political ideologies one has, and all these factors then become very important in determining whether you would or would not have FCI registration. Yeah. So, I mean, I'm trying to keep it more practical in the sense I'm trying to share my experiences than getting into what the act is, what the definitions are, because that's something for everybody to read, and there's nothing too hyper technical about the definitional aspect. But I think I think it would be better if I take you all through to our experiences of these nuances that we keep coming across when we interact with NGOs, and what challenges do they face. Yes.
Jumping in here, Rahul.
Yes, yes.
Before we move on, we have a question from Mr. Anil Krishna, who asks if you could please share the relevant provision which changed the situation. Now, Mr. Anil, could you please clarify which section in particular? And I'm sure Mr. Rahul will be very happy to address it.
Okay, so the question is, could you shed some light on whether NGOs having HCI registration using grant money from a foreign source for charitable purposes are exempt from GST or not? Sometimes the NGO...
Sorry, no, Rahul, there are two questions. One came in the Q&A, which is the one from Anil. Maybe you can take that first, and then you can take the second one, which has come from Tanvi, which is the one that you were reading in the chat. So in the Q&A,
Okay.
What Anil has asked, he said, could you please share the relevant provision which changed the situation? I think he's referring to something you were mentioning earlier. Anil, are you online?
Sure. So, yes, we had run a very detailed hotline in the year 2020 when these amendments had come in. If I can have Anil's email ID, or if he can drop me an email, I'll be more than happy to share our detailed hotline on that, which has all nuances of amendments that were carried, and specific changes that were made into specific sections and subsections. I do not currently recall all of those subsections in exact numbers, but our hotline had, which I had co-authored, had a detailed analysis of all those changes that were made, and I will be very happy to share that with the folks who are attending the conversation here. Yeah, the discussion rather. Yeah.
Great. So Rahul, maybe we can send that as an email as a follow-up to all the participants who are here.
Sure. Should I type my email ID here, or I'm sure they would have?
No. We have a contact us page coming up at the end of the presentation.
Okay.
I think
fine.
the question that you can take is maybe Tanvi's one then, where she said, could you shed some light on whether NGOs having FCRA registration using grant money from a foreign source for charitable purposes are exempt from GST or not? Sometimes the work the NGO is doing. Yes, go ahead.
Understood. So yes, that again, this is a very relevant question, because we keep getting this query quite often. Two things. One, it is only a certain class of NGOs that are completely exempt under GST, right? And those exemptions have simply been transported from the earlier provision onto the GST Act now. So, for example, if you are an NGO which works in the field of HIV/AIDS or in public health field, and you cater to specific medicinal needs, only certain type of such NGOs are exempted from GST. So the bracket is already quite small. Most of the NGOs do not operate in that space, right? Most of the NGOs. So as a thumb rule, assume that GST is applicable to you. Second, at what stage would GST be applicable to you? It would be applicable to you once you cross the 20 lakh threshold, is what there is for NGOs as well. However, if you were to raise invoice, if you were to raise a certain invoice to your foreign client, right? Now the question is, do I need to, have a markup of GST when I invoice to the foreign client? The answer is yes, for the reason that under GST, there is a reverse charge mechanism. So you will be expected to file that GST part of compliance on their behalf. So more often than not, when you invoice your clients, and these are commercial receipts, do make sure that you integrate your GST markup into the cost when you do it. That's a lot simpler way to go about things than assuming that should I be exempted or should I not be exempted. As a thumb rule, for such invoices, please integrate your GST markup into your invoice as well, irrespective of whether you have a certain threshold or you do not have a certain threshold, because at some point of time you would have. And even if you do not have that certain threshold and you say that, look, I should be exempted, I would still suggest and rather advise that go for a GST registration. If you do not attain the threshold after which you need to make the filing, the best you do is to file a nil return, right? But it is still advisable to have a GST registration, because you never know when query starts to come from different agencies, it becomes very tricky. So it's, as a thumb rule, from the day you start your operations, have a GST registration in place, and when you invoice, integrate those GST component into your invoice as well. If you do not achieve the threshold beyond which the GST payments are triggered, you file a nil return, but at least you have that mechanism in place, is what my advice to you. Yes. Next question.
Thank you, Rahul. Anilji has clarified that he requests the clarification on which relevant provision changed the situation pertaining to your earlier point about subsidiary companies, wholly subsidiary companies.
Okay, yes, interesting. So that amendment, that amendment, interestingly, was not made under FCRA, and hence the confusion. The amendment was made via amending the Foreign Exchange Management Act through a finance bill in the union budget. And hence, a lot of people have this confusion because they keep looking at FCRA Act to understand what the amendment was, but you will never find the amendment in the FCRA Act. The amendment was made via the finance bill into the FEMA provisions, which then had an effect on FCRA. Yes, I'll share that. It is a 2017 or 18 amendment, as far as I remember. Yes, but FEMA was amended, not FCRA. But in effect, it had an effect on FCRA in that sense, because they very much changed the definition of what a foreign source is, which, I mean, in an ideal situation, they should have done it through the FCRA amendment. But the law itself is quite strenuous, and the process of amending it is also quite opaque at times, and hence this confusion. But yes, the amendment was not made directly into the FCRA Act per se, but it was done through a backdoor. I'll share the amendment provision as well that had taken effect back then. Yeah. Yes. Any more questions do we have?
We'll keep you updated, Rahul. I think we can carry on for the time being.
Next slide, please. How much time do I have now?
You have about 30 minutes more, Rahul.
Okay. So this slide is about fund management. Fund management, which on private. Yes. Okay. Interesting. Yes, this is an important aspect. So once you have had received FCRA money into your FCRA designated account, which is now to be set up in Delhi with the SBI, State Bank of India branch. Now, let's say in a scenario where you as an NGO you are operative in the state of Arunachal Pradesh or in the state of Assam. Now, how do you again keep going back to Delhi to withdraw your money? That would be practically insane for you to do. So the idea is that once you have set up an FCRA designated account with the State Bank of India, Delhi, Sansad Marg, you are also allowed to have utilization account. So once you have a central account opened with the FCRA, designated FCRA branch at SBI, you are allowed to create utilization account in your home state, and the utilization account can then use that money being transferred from the FCRA account. So that should be fine. Now, once you setting up of a utilization account for the purposes of channelizing your FCRA fund does not mean subgrant. The reason being that those utilizations account or sub accounts would still be operated within your own entity framework, right? So if you have an account in Delhi and you set up a sub account in Assam, the sub account is very much eligible to receive funds from the designated FCRA account that you have in Delhi. And transfer of funds from the designated account into a sub account will not be considered as sub-granting, right? Sub-granting for the purposes of FCRA means that if you have an FCRA account, the money cannot then be transferred from one FCRA account of one entity to another FCRA account of another entity, right? So there's a clear difference now, understand that, right? So creating of a sub account or utilization account within your own setup does not contravene the prohibition on subgranting. Transfer of FCRA money from one FCRA designated account to another FCRA designated account is completely prohibited. Please take note of that. I think NGOs have taken note of that because I think the law itself is such that they have no other choice but to take note, sadly. But yeah, another example here is that be very careful about using your FCRA account to enter into service contracts. Like for example, now this is another case that had come to us where a leading non-profit in India, which is quite active in the space of vocational training, had an FCRA account. And for some reasons, they thought that they should also be engaging with certain for-profit and non-profit vendors. Like for example, if I get a project of, let's say, rupee 100, if I get a project of 10 million USD and the project is on vocational training and the mandate is for me to train different students across the northeastern parts of India, and I'm not present in northeastern parts of the country, certain NGOs are present there who for me are nothing more than vendors. Now how do I engage them? And those vendors were for profit as well as non-profit. Few of the vendors had FCRA and few vendors were pure for profit vendors. Now the NGO then had, our client had then used their FCRA account to enter into service contracts with vendors who had FCRA registration. And then at the time of audit, MHA was of the view that, look, this is a clear violation of the prohibition that we have put on subgranting. And to a large extent, their argument was correct, right? So we had to then explain it to the authority that, look, yes, it may seem as if this is very much an indirect subgranting, but look, our transaction was not malified. Our intent was not there to defeat the subgranting purposes. The only reason why we entered into that was because of the fact that there were very few vendors that were operating in that geography, and the nature of the project demanded a service payment because, you know, we had some milestone payments to be made and we had some impact studies to be done, and it was not a project that was largely driven in a philanthropic manner. It was a project where we had to look at certain outcomes against fundings that we would make available to non-profits. So we had to do a lot of technical explaining to the MHA, which took a lot of time. Eventually they did come around that explanation we offered them, but it was quite tough, you know. So for an NGO who has FCRA registration and who wants to also work with peripheral vendors or non-profits on the ground, please be very careful about using your FCRA account. If you have an FCRA account and you still want to engage with vendors on the ground by way of a service agreement, you should be fine using your FCRA account to enter into service contract with for-profit implementing agencies. But the moment you use your FCRA account to enter into service agreements with another NGO who also has FCRA, then it could be construed as a clear violation of FCRA prohibition about subgranting, which is section 7. If you enter into a service contract with another NGO using your FCRA account, and that NGO is not in receipt of FCRA registration, such transactions may also again be construed as an indirect contravention of Section 7. And it may be construed as if you are indirectly entering into a sub-granting prohibition, right? So there are three elements that we have to keep in mind. If you are a lead NGO having FCRA registration and you want to engage with vendors on the ground, for profit and non-profits, right? If the non-profit vendor has FCRA registration, do not enter into a service agreement. If the non-profit vendor has no FCRA registration, even then do not enter into a service agreement while using FCRA funds. FCRA funds should only be used when you engage with for-profit vendors. And the rationale behind it is that for-profit entities are per se not eligible at all to receive foreign contribution. We all agree on that. So if I am not prima facie eligible to receive foreign contribution in the first place, then even if I were to enter into, as a vendor, if I were to enter into a service contract with an FCRA registered entity to receive certain remittances, I would still not defeat the purposes of sub-granting prohibition in the first place. And hence, it is a lot safer for you to engage with for-profit vendors when you use FCRA money than to engage with non-profit vendors. And please be very careful about that, because we have seen instances where engagement with non-profit vendors using FCRA account has been construed as an indirect contravention and their FCRA licenses were put on hold. Yeah. Okay. So yes, there is the exceeding the 20% now. Another important aspect that we also keep coming across is the usage of admin versus non-admin fund. Now, let's say, for example, you as an NGO are funded by a foreign agency to execute certain programs on the ground in Nagaland, for example. Now, how do you go about ascertaining whether the expenses you incur on hiring specific personnel should be admin expenses or should be non-admin expenses? Because the only exception to the 20% ceiling is that if you are engaged in programmatic expenses, then administrative costs that you incur on such programs should not be hit by the 20% ceiling that otherwise is applicable to NGOs across the board, right? So we have to be very clear as to whether we are hiring certain individuals at an operational level or at a programmatic level. If, for example, I as an NGO operate a program on preventing adolescent marriages or early marriages in Jharkhand, for example. Now, that is a clearly distinguishable and distinct program that I have, amongst other things. And if I were to operate in, let's say, a district like Ranchi, okay? Now, if I were to hire certain personnel purely for specific project of mine that is to look at early child marriage issues in Ranchi, then the administrative expense that I incur on hiring those personnel should not be hit by the 20% ceiling that is currently applicable, because the expenses that I incur are towards the programmatic part of my execution on the ground. However, if I were to hire a CFO or a CEO, for example, at an operational level, at a level of my governance, and if the salaries that I pay to her is of that nature that it exceeds the 20% overall threshold of my overall FCRA income, then that is a problem. So I want our viewers to understand the difference between the 20% ceiling that is applicable. If the 20%, if my hirings are at a level where I have CEOs, CFOs, or managers who are engaged, and these managers are not engaged to do any particular programmatic part of my execution, right? They are for generic operational purposes. Then I have to be very clear and very careful that I should not breach the 20% threshold that currently there is. But if I want to hire specific experts for my program on a short term or on a long term or on a project life cycle basis, and if that leads to me crossing the threshold of a 20% markup, that should be fine. I hope I was clear in explaining that. If there's any question, I can wait and answer it. I think we have another question.
Yes, Rahul. I was hoping for a little break. I didn't want to interrupt you.
Yeah, go ahead, Sean.
Yes. So this question that you were just reading: can the entity with FCRA make a contract to farmer producer companies, which is a for-profit entity? I believe you were just discussing it, and I believe.
Yes, I think FPOs for profit should be fine, but again, we'll have to look into the. I would say, so Ganesh ji, if you say that we can make a contract with a farmer producer company, what would that contract be for, right? I think we'll have to also look into that. If so, let me just add another statement to it. Entering into transactions are absolutely fine, so long the NGO should not merely act as a pass-through entity. So I should not be the bus stand where buses come and buses go. If that is my job, then there is a problem. If I as an NGO want to enter into a service contract with a for-profit entity, that interaction should be in form and substance. It shouldn't just be because I'm an NGO and I'm allowed to enter into a service contract, so I'm going to receive certain monies from party A and simply be a conduit to transfer that money to party B. So that optics has to be very clearly understood. And not just the optics, but the rationale has to be clearly understood. If there is an indication that I'm merely acting as a conduit or as a vehicle or as a pass-through entity, then we are in trouble. If there is a genuinity of the transaction, if my activities that there are on the ground warrant me to enter into transactions for me to execute certain programs of mine on the ground, or if my business model warrants me to engage myself with these separate vendors, then such payments should not be questioned by the ministry. And if at all they are questioned, I think providing basis are rationals that we provide, more often than not, they become fine with that. So we have to be very clear about the reasoning and the rationale as to how we divert or use or utilize those funds while we interact with similarly placed NGOs or with non-profits or for-profit vendors.
Thank you, Rahul. We have two other questions.
Yeah.
One is from Anup Kumar, who asks, what is the role of blended finance in NDC for developing countries like India?
Interesting. Sorry, what's the role of blended?
Blended finance in NDC for developing countries like India. If Anup can clarify what NDC is, I think. Rahul
what's NDC?
While we're waiting for Anup to get back, we can, if I may run another question by you.
Sure, go ahead.
Anil asks again, is it a good practice to use SBI accounts for operational purposes? Or should NGOs avoid using SBI for operational purposes in the context of the FCRA registered NGOs having the SBI account? Having the FCRA, I assume, the FCRA account with SBI, but not having the utilization account with SBI. Is that a good practice?
You may have utilization account with any other branch or bank as well. I don't see that as a problem. And it's always, look, I think it is for the NGOs to decide whether they want to have a utilization account, and if they want to have a utilization account, where exactly do they want to have it? I mean, it's a given that if an NGO has multi-state presence, then operating through a single account is going to be a nightmare, right? So I think it's up to the flexibility that NGOs have to decide whether they want to have a utilization account or not. They can have a sub account. The law allows you to do that. It's just that it also increases your compliance a bit, where you have to have a person who wants to keep a close tab on how the funds are channeled internally. But I don't think having a sub account should have any additional pain points for you. It's just that you need to be very sure and certain about how you use it and utilize it. But if the law permits you to do it, why not do it? If you have multi-state presence, if you're only operating in one state, then I don't see a reason why you should have a sub account. But yes, if you have parallel projects running, right, it's always advisable to earmark one sub account against that project, so that at least your you are better positioned to uh, oversee those channelization of funds or those disbursements of funds or deployment of funds than using one account to make all the transactions. But again, this is a function of how efficient your accounts officer is and how good you are with your books. The law allows you to have those sub accounts. How you use it is up to you.
Wonderful. Thank you. Thank you very much. Would you be okay? Anup Kumar clarifies that NDC means the nationally determined contributions.
Sorry, come again.
So the earlier question is, what would be the role of blended finance in the nationally determined contributions for NDC for developing countries like India?
Interesting. Yes, this is a very good question. And while I cannot take names, but I mean, I can take one name. So in the year 2020 and 21, we were the lead counsel for the consortium of parties that had come together to launch India's first impact bond centered around vocational training and skill development. So that was India's first impact bond around skill development, and it was a huge success. We were the lead counsel for that entire transaction, which consisted of 12 to 13 parties, and it was a mix of foreign offshore donors, offshore risk investors, domestic risk investors, and domestic CSR donors. And it's in public forum, so I can take names. NSDC, MSDF, CIFF, and these sort of non-profits were engaged. And domestically, we had HSBC, and we had some other CSR funders as well. Now, why is blended finance that important? Is for the reason that a lot of non-profits have slowly realized the fact that FCRA is becoming a tough nut to crack, right? So they are looking at alternate models where the outcomes that are achieved on the ground is tied to certain payments that you received as a donor in the first place. And then blended finance, to that extent, offers us a unique model where you have different players who would want to be a part of your game basis what risk appetites they have. For example, if I am a domestic NGO who wants to support other NGOs in the field of, let's say, literacy, but I also at the same time want to make sure that if I am funding another NGO, like let's say for example Reliance Foundation. Now Reliance Foundation is a huge foundation. They have very healthy corpus, or Tata Trust for that matter. Now it might not be always practical for them to run all the projects on their own, and then Tata Trust doesn't do that either. They have different non-profits on the ground whom they support in Orissa, Jharkhand, West Bengal, Kerala, Tamil Nadu, and they provide grants to them. Now, what blended finance says is that, look, it's good to provide grants to them, but why don't you tie those grants with certain outcomes that you want to necessarily have? So I think somewhere our philanthropic ecosystem is in a transition phase where it is now starting to realize that we want to have maximum bang for the buck, and hence if I am going to deploy my money to another NGO, I should tie those monies to the outcomes that I expect the NGOs to give back to me. Because then I also have to take those outcomes to my board and tell them that if I deployed rupee 100 crore, what is it that I have achieved, right? Secondly, we have also started to see a lot of CSR foundations that have started to use their own CSR funds to make outcome payments, which is to say that, look, if there are parties who have come together to say that I want to reduce illiteracy in a certain districts in Bihar, right? Then Reliance Foundation says that, okay, fine, let me sit back, let me see you guys performing. At the end of your first year, if you guys would have reduced illiteracy by 5% or by 10 percentage point in a certain district, then I, as a CSR funder, will make my outcome funding to you, which is to say that you guys take the upfront risk of deploying your capital, you give the results to me, I am satisfied, I use my CSR contributions to make to pay back the funds to you by way of a contribution and through that I comply with my section 135 compliance, because the moment I write a check to you, I am done with my CSR. At the same time, my CSR is deployed towards uh, outcome, performance linked outcomes, so which I can measure. There are certain metrics to it, and it is more impactful. That very much is the nature of what blended finance is, where essentially blended finance is nothing but a vehicle that allows different stakeholders to be a part of a project cycle basis their different risk appetites. Like, for example, if I'm an NGO that says that, look, I have rupee 100 to spend, but I also want to make sure that I should be incentivized to achieve certain outcomes. A lot of times, donors simply write a check, they give it to an NGO, the NGO does the work, whether there's impact, there's no impact, nobody cares, there's no measurement done to it, right? And the life and life moves on. Blended finance tells us that, look, why don't we identify different players basis what risk appetites they have. So if I'm an NGO who says that, look, I want to spend rupee 100 to train certain kids or to educate certain kids, but at the same time I want to be incentivized because I have my house to run, I have my staffs to pay, and I needs to be incentivized, right? Now, you as an NGO cannot possibly be incentivized on a for profit basis, because that would run contrary to your objectives and run contrary to your tax provisions. But incentivizing does not simply mean that I write a check to you and give you money on a for profit basis. I can always, so if I spend rupee 100 as an NGO to take upfront risk, Reliance Foundation can always come and tell me that, look, okay, fine, if you give me certain numbers, what 100 rupee you had spent on the ground, I give you 120. That 120 would still come to you by way of a contribution, but that additional 20 is your markup, which is your profit. And basis income tax act, you still have to replow back that profit into your operations. So you are technically not profiteering, you are profiting, but those profiting again is in line with the income tax act, which allows you to profit, right? So that's the blended finance concept, where we use different set of players to accommodate them at their different levels of risk appetite to ensure that we have a mix of foreign contribution coming in, CSR contributions coming in, risk investments coming in. Now, why is it called a blended finance? Because let's say a scenario where you have a vocational training project in India, right? And there are domestic players. Let's say, for example, NHDC. Now, NHDC is a big player in Indian market, right? Now, there could be a scenario where foreign non-profits may want to provide upfront risk capital to NSDC. Now, that upfront risk capital deployment to NSDC could be by way of a FCRA grant. It could also be by way of providing a debt, right, through external commercial borrowings. It could also be by way of providing a service fee to them, right? Because there are different ways through which monies can be brought into India, which could be a blend of FCRA, domestic CSR funding, service agreement, debt servicing, equity infusion. Hence, we use the term blended finance, where it is accommodative of all different sources of funding that may come in, so long those are compatible with our laws. Yeah, are we good?
Yes. Yes. Thank you. Thank you. Thank you.
And mind you, blended finance is the way forward. It is the way forward. The way we are seeing a concerted effort by the government to nudge NGOs to be listed on stock exchange. There is greater norm of transparency requirements. Foundations have now started to get into the impact measurement space as well. There are dedicated project management services that NGOs have now started to provide. I think coming years from now, blended finance is going to be the way forward, where I do see a lot of collaboration taking place between foundations themselves, where they would come together and form a larger corpus pool to act as an outcome funder, where we could have another set of players who would come together to act as risk investors, and probably foreign offshore non-profits could look at providing additional incentives to these domestic players, and that's how scaling up is going to happen. So blended finance is going to be the way forward. For good or bad, I think that's for time to tell us, but so far blended finance has been able to at least achieve certain measurable outcomes, and there are a couple of significant players that are quite active in this space. For example, Magic Bus, Nudge Foundation, People, Livelihood Foundations, NSDC. In fact, you name all big non-profits, whether in India or abroad, they have their skin in the game.
Understood. Thank you very much, Mr. Rao, for that very concise argument point. We'll take one quick question before we let you proceed. Mr. Nagaraj asks, he has a question on executive director salary. Can we bifurcate ED salary between admin and program based on this contribution of the work?
No, you can't do that. You cannot have an executive director performing a program, right? The executive director would essentially be at a more board level or at a more operational level. So you cannot possibly have an executive director who would argue saying that I have hired this executive director to perform my program. I think it won't cut much ice.
So there is no scope of, say, bifurcating.
Not really. That would be too tough to debate. Yeah,
and program. Right.
Yeah.
All right. So we'll take the presentation forward, Rahul, and then any further questions we'll keep interrupting you as we go.
Okay, there's another question from Ganesh. For the NGOs, is there also a list of foreign donors who may have challenge from MHA perspective to give? Interesting. In some case, yes. So Ganesh, I think you are referring to the prior reference category list that there is, which is an internal document which is not in public forum, and there is some internal mandate given to the SBI bank and to other AD banks to make sure that any transactions that happen from certain foreign non-profits do not enter India's territory. And that is the PRC list, which is colloquially used. We do not have access to the PRC list. We do not know who are the members that currently continue to be in the PRC list. In general parlance, we call it as a watch list. In the past, there were certain NGOs that were in the watch list. For example, Omideyar, Hewlett Foundation, and I'm saying this. I'm taking these names because these are already in public forum. But right now, how many of them continue to be under the watch list? I am not privy to that information. I do, however, can tell you that we do get queries from our specific clients when they deal with certain non-profits in India who have not been very friendly with the government of late for some or the other reasons. And at times there is a fear that such transactions would get blocked because such foreign donors could unfortunately happen to be blacklisted or be put under the watch list. And this has happened in the past, but we do not get any prior intimation on that. We only get to know once transactions get blocked, and then they write us frantic emails as to what's happening and what is the way forward. But yeah, there is certainly a watch list, and the watch list continues to grow. That I can tell you for sure. Yeah. But again, a rider there. Just because you happen to be, let's say, for example, ABC Foundation, a US based foundation. Just because ABC Foundation happens to be under the watch list does not mean that all the transactions that emanate from that foundation will necessarily get blocked, right? Now, a certain foundation could work with an NGO which is active in anti-trafficking space. A certain foundation could also be engaging with another non-profit that is active in education space. So, for example, if the government has issues with any domestic NGO or their work in particular in a particular territory, but for political reasons or otherwise they are not in a position to go after that domestic NGO per se, a better way to ensure that they are given the right message is to put their source of funding under the watch list. So once you dry the tap, the water doesn't flow anymore. So that's the entire logic, right? But that would still not mean that all transactions emanating from that foreign NGO would get stopped. Probably only certain specific transactions which may be directed towards anti-trafficking or modern slavery would get stopped, but other quote unquote non-controversial projects, let's say in the field of literacy or Swachh Bharat or Clean Ganga, would still continue to come. So do not assume that if a certain foreign foundation is under a watch list, everything is doomed. No, we have seen instances where some transactions were blocked, but other transactions were allowed to come through. Now that again is a function of different sectoral presence that those funding agencies have in India via their vendors that they work with. Yeah. Yes. I think I'm mostly through with the questions.
Yes, we're up to date on the questions so far.
Great. I think I have covered most of the slides now, unless you want me to recite those slides just for the sake of it. But I think I have more or less covered most of the important nuances, granular issues that at least I have as a practitioner come across FCRA basis our interaction with our clients and with stakeholders. If there are any more questions, I'll be happy to take it up.
I think Ganesh
the
has
renewable
one more.
extension for
Yes.
NGOs, it keeps on extending. Please redirect this question to the Ministry of Home Affairs. I am the wrong person to answer it. But I think this extension business will continue up till general elections. Once the elections are through, probably we'll see some level of stability there. But I don't know. I mean, MHA is understaffed. The investigation process, the scrutiny process has become a lot more engaging and cumbersome. And it's quite obvious that because of all of those procedural, I would say, cumbersomeness, these extensions have become the norm of the day, because it's literally impossible for the MHA officials to do a complete stock of what you are up to and then give a final assessment before the processor application. So the best they do is to give you ad hoc extensions. That also keeps you on tenterhooks, right? It keeps you on your toes, and MHA likes that. Yeah. You see any changes once the elections are done or the results announced from? Absolutely. Okay. Let me put it this way. I'm anticipating FCRA laws to become even stricter and stringent, more stringent in coming years, in coming months, basis how elections pan out. Yeah. I do anticipate NGOs that work on affirmative actions or on, I would say, constitutional issues, right? Such classes of NGOs will face more and more scrutiny. Think tanks in particular will, I classify them as vulnerable group as we do it in wildlife, you know. They are the vulnerable class right now. And basis how the election results pan out, and it's nobody's guess as to how things would change for good or bad. But if the current government dispensation continues to be in par, then the political understanding that they have on FCRA would only strengthen a lot, which means that organizations that are run by minority members or such board members that do not subscribe to the majoritarian views or to the views, the political views of the current dispensation, they would continue to face further scrutiny. Now, a lot of them have taken certain measures to ensure that they at least appear to be neutral, politically neutral. Now, again, politically neutral is a very loaded term, so I don't even know what it means, frankly. But if you do not subscribe to certain uniform understanding of what the polity is in the context of the current dispensation, then I think you would more often than not have FCRA scrutinies. And I think it also is a function of what sectoral presence you have. If you are into vocational training, skill development, nobody cares what you do. Everything is hunky dory. But if you are into land rights, if you are into tribal movements or rights, or if you are into such affirmative rights that form very thematic component of constitutional understanding of our rights as we have them in our constitution, then there is certainly an issue. Yes. That is all the limited nuances I can currently share with you without going all bonkers about wanting to say more. Yes. Yes. Any more questions do we have? Great. I think we are almost through with our.
I believe,
Can you hear me?
I think we just got a question that's come in. Sorry to jump in
Yeah,
from
sure.
Shachi. She asks, or he asks, sorry, our trust's registration number is changed as the registered office location has been transferred to a newly formed district, which is separated from an earlier district. Do they need to
Mhm.
inform this change to the ministry, and if so, under which form?
I do not remember the exact form. I think it should be Form 6E or something. I'll have to check that, I think. But if the registered address has been changed, then yes, you need to inform the authorities. If the registered address has changed because of any statutory implication or by way of a bifurcation of a state, then I would assume that it's something which happened because of certain government action. So I think even then it's advisable for you to inform the MHA. Yes, certainly is. Yes, you should. Yeah. Any more questions we have? No.
I believe, yes, they're coming in. So Tanvi has come back with another question. She says, I read this somewhere that consortium contracts where multiple Indian FCRA registered NGOs as partners together to undertake a project will no longer be permissible unless the partners are covering their costs with their own funds. What is your opinion on this?
Sorry, this is a very specific question. I think I'll need more elucidation on that before I'm able to give my 2 cents on it. Uh, I am not able to gather the what the question is exactly about.
All right. So consortium contracts in
Uh-huh.
contexts where there are multiple Indian FCRAs registered
Yes,
as NGOs, when these
yes,
multiple parties partner together to undertake a project,
yes,
this
yes.
situation will no longer be permissible under these unless these partners are covering their individual costs with their own funds. Is that a correct understanding? And what might be your opinion on this thing?
I mean, consortium contracts have been in operation, and under the consortium contracts as well, each of the respective FCRA registered partners take care of their admin expenses separately. In any case, you are not allowed to mix FCRA funds. So even if if you're a part of the consortium partners, you have your specific FCRA account to deal with, right? You do not mix funds. You are not allowed to do that anymore. So in any case, as much as let me give you an example. Take the example of India Alliance. It's an alliance under an umbrella, but all respective parties have their own independent existence, right? They It's not as if just because you enter into an alliance you start sharing funds as well. That is not going to happen. They have their own electoral funds in respective states and their own strengths and weaknesses. Something similar is what there is with the consortium partners. So if there are consortium partners who are a part of a single assignment, and all of them are FCRA registered, even then they do not share FCRA resources together. They can share IPs, they can share intellectual property, human capital, but sharing of funds is not allowed. So whatever expenses you are going to incur on your admin or non-admin will be a function of what funds you are sitting on and what is the threshold that you have to follow. If I have understood the question correctly, I still not have understood the question correctly for me to answer it in entirety, but to the extent that I have contextualized it, I think this is what I have understood it to be, and hence my response accordingly.
Maybe Tanvi, you could unmute and explain your question better for Rahul. Oh, sorry.
Yes, I'm not sure. I'm not sure if they can
Participants
participate
may not be able to unmute.
verbally.
Tanvi, would you like to clarify over chat so that Rahul can see what your question is more clearly?
And while Tanvi does that, we might Rahul might take another question from Gitanjali, who asks, are there any governance or operational guidelines that you can provide on the relationship between foreign donors and FCRA entities? For example, can the foreign donor be involved in hiring a country director or key administrators for the FCRA entity?
Please do not do that. Please do not do that. Do not. No. No. Okay, so I'll tell you the rationale behind it. See, technically, a foreign donor is very much capable of ensuring that a certain individual is hired which is to their liking. Okay, or there could be some strong recommendations coming along. And foreign donors often do that if they provide you that healthy sum of money, they are well within their rights. But under FCRA law, there's a concept of direct ownership and control and indirect ownership and control, right? What FCRA is more touchy about is indirect ownership or control. See, direct ownership or control is something which FCRA authorities can simply check and put a tab on, because that's something which there is clearly under law. So you do not operate in shadows or beyond law propositions, right? But in scenarios where foreign donors would want to hire a CEO or an important office bearer onto their grantee governance setup, ideally they should avoid doing it. And even if they want to, at least be smart enough to not do it via any paperwork. If at all they still want to go down that path.
But you would generally advise they stay away from making administrative decisions.
Because any level of indirect presence by a foreign donor on India's FCI registered non-profit is typically discouraged and not appreciated by the authorities.
Thank you. Thank you, Rahul. If there might be any more questions that any of the attendees might have regarding FCRA, whether your organization is your organization registered to begin with and licensed under the Act? Have you or your organizations have to file details under any of the forms that are mandatory under the Act? Do you or your organizations intend on registering yourself to receive foreign contributions, or are you facing any issues currently? If any of the attendees have any inquiries that relate to FCRA, please put them in the chat so Rahul can address them. Tanvi, we are awaiting your clarification on the consortium question. Okay. Okay, so she has qualified her question on the consortium arrangements, Rahul, by she's found a statement in an online ready reckoner on FCRA, which states that the donor has to work with only one Indian registered implementing partner at a time. So in that context, if there are multiple organizations that are FCRA registered that are working together, would that yes? So would they be able to collaborate on a project?
So I just clicked on the link that Tanvi had shared Look, I don't know from where FMSF is getting this idea, but at least I can tell you, basis current transactions that I'm working on blended finance, we have foreign donors who have multiple vendors and implementing agencies in India that they work with, and there has not been any problem, and they have all been FCRA and non-FCRA registered. I think one general advice that I have for all the viewers or listeners here is that do not over subscribe and over rely on certain blogs that you come across where all chartered accountants happen to believe that they are FCRA experts. They are not. And I do not say this with any disrespect, but it does create a lot of confusion. For example, the statement that she just shared with us within quotes, the donor has to work with only one Indian registered implementing partner at a time. I think I would like to see what the FCRA provision on that says. If it doesn't say, then I think any analysis that our experts make on their blogs is rather stupid, is all I can say.
Yes. Yeah, because Tanvi also mentions that she could not find anything pertaining to
Yeah, I mean,
that
ये is a
specific.
problem. या प्रॉब्लम ये है ना कि एफसीआरए में प्रॉब्लम ये होती है कि ज्यादा स्केयर मॉन्गरिंग भी होती है और लोग अपनी एनालिसिस देते हैं जहां पे पीपल थिंक दैट they know what FCRA is about. I mean, there has to be some legal basis. And think about it. If tomorrow FCRA tells me that you as an NGO can only work with one vendor, will it not run contrary to Article 19(1)(a) and 19(1)(g)? I mean, at least let's use some common sense before trying to
Fundamental
be
level.
experts on FCRA via some blogs. And with no disrespect to any expert, but I mean, let's not take it that far jahan pe we start looking at FCRA as some sort of a Godzilla. That's not the case. I mean, it is weaponized to some extent, I agree, but people still find ways to operate and they have been, so it's okay. Yeah.
Right. So final clarification in the sense of if there is a foreign donor entering into a tripartite agreement with two Indian-based NGOs which are FCRA registered, there is nothing in the FCRA guidelines that this would be contravening at least.
Sir, if there were to be such a clause, assuming in a hypothetical world or in a parallel universe, it will get struck down by the court. It would be unconstitutional. It's an unreasonable restraint on your freedom to trade. I mean, it just cannot be. See, the government could still have different ways to make sure that you are not allowed to operate. And they could have extra legal measures against it. But would any government be stupid enough to put that in writing within the act itself? No. Right?
Yes.
Yeah.
Thank you, Rahul. Would you be able to elucidate a little bit more on non-compliance, if you would like? Maybe touch upon the effects of non-compliance, maybe, or on the impact of international donors before we wrap up for the day.
Sorry, come again. Non-compliance with respect to international donors.
No, just in brief, if you would like to just touch upon.
Rahul, you have two more slides. One is on the effect of non-compliance, and the other is on the impact on international donors. So we were just wondering if you want to go through to those slides, or if you feel you answered those points already.
No, I'll just quickly through. Yeah. So effect of non-compliance, frankly,
Next slide,
is
please, Yash.
Yeah. So the opportunity cost of not comply has, I mean, okay, let me put it this way. Non-compliance may lead to severe consequences if the non-compliance is with respect to not filing returns on time or not intimating FCRA authorities on time on issues that are non-negotiable for them, then yes, you are in some trouble. If certain non-compliances are purely administrative in nature, then there are provisions to compound it. In fact, I tried to go for a compounding application for one of my client. It's been 4 years now. I haven't heard back. So as much as compounding provision there is in the act, the MHA does not believe in compounding. They just don't. So assume that all of your non-compliances are going to be tricky for you. So to the extent possible, my humble request is to over-comply but do not under-comply. I'm just trying to make a generic statement here because we have already crossed our time and I have another call at 12:20. So I'll have to rush. So that's the effect of non-compliance. But yes, the effect of non-compliance has increased manifold, and there are penal provisions as well. There are penalties as well, and for people who are found to be responsible for such compliances, and if they are not, then there's also provision of imprisonment and or fine. Yes. Next slide,
Okay,
please.
thanks, Rahul. Yeah. Maybe you can skip the judicial trends since you're short on time also,
Yeah,
Rahul.
on judicial trends, yeah. On judicial trends, I'll just keep it simple. If you are a well-funded NGO who has good presence in Delhi, chances are high that the High Court will give you some reprieve. Otherwise, they don't care. I have no other ways to put it. I mean, I have because that is what it is. If you're an Oxfam or some well-funded NGO, then yes, you can still approach the High Court and you can fight it out. But if you are a Chota NGO, forget about it. Not happening. Yeah. Yeah.
Next slide.
Pivotal and relief conference. Yeah. Okay. National security concerns. Again, also, I mean, uh, I think what we have to understand is that look, the trend that I see is that high courts or judicial forums have largely upheld most of the amendments that the government had made in the past. The courts have largely been averse to striking down a prohibition, a provision, sorry, of the amended law. They do not find reasons to declare it unconstitutional or ultra vires, as much as on the face of it, it may look to be ultra vires or unconstitutional. And the disturbing trend that I have been seeing, at least vis-a-vis the high courts, is that more often than not, they want to read down those uh, uh, harshness in the law than declare it unconstitutional. And it is for that reason that I made a politically loaded statement that if you are a Chota NGO, forget about it. Because one, NGOs have become very wary of approaching the High Court via writ petition to seek redressal because of fear of reprisal. That's one. Two, High Courts themselves have not lived up to the fact that a lot of times when the government has been high handed with NGOs, they have not been able to provide them that level of protection. And thirdly, the FCRA law by the agencies and by state institutions have also been largely been understood to be a securities led law. So when matters relating to state security and sovereignty comes into picture, or if matters of public interest vis-a-vis MHA comes into the picture, high courts at times also take a more liberal view and tend to agree with whatever the government side of arguments there are before the bench. And hence, more often than not, we do not see an outright or even some reasonable support that there would have otherwise been to offer to NGOs who would have considered themselves on the harsher side of the MHA actions. And this is what the judicial trend current is. And I do not see any improvement in that. Because look, judicial trends on FCRA is a function of the master who orchestrates the FCRA Act itself. So if the master is a believer of using the law liberally, then the courts are largely reflective of that ideology. If masters of FCRA believe in its stringent enforcement, then courts more often than not go along with it. Unless something really insane happens and the courts really have to intervene, they really do not. And FCRA, I don't think is that important a public cause or concern, frankly, either electorally or otherwise. So yeah. I mean, if 100 stray dogs are killed in Kerala, I think the court would take more cognizance than 100 NGOs licenses being cancelled. Yeah. I know I made a very loaded statement, but this is a fact. Because the courts more often than not read down the clauses. They don't declare outright unconstitutional provisions as unconstitutional. So I do not have faith in saying that the courts are there for providing reliefs. More often than not, they do not. And if you are deep pocketed, you will find good lawyers to defend you. But if you are a Chota NGO working in small states, where do you go? You go nowhere. I have seen NGOs that have shut their shops in Jharkhand who were operative in tribal districts and who had good source of funding, and post the amendments under Section 7 of the FCRA Act, where subgranting was prohibited, a lot of these NGOs had to fire people and a lot of folks lost their jobs. And it's a fact. We do not still see FCRA as a law that should provide livelihoods to people. A lot of folks in rural India were employed because FCRA funds could sustain their livelihood, and a lot of them have lost their jobs. And it's a fact. It's not just a state law. It's a law which is linked to livelihood and to income and earning of people concerned. So definitely, I think it has had a great economic side effect to it, which nobody is willing to address, sadly. But yeah, that's the harsh truth. Anyways, yeah, that's all for me, folks. That's all from me. Any more questions do we have?
Yeah, Rahul, I think your next slides were just about the impact on international donors, and then you
Yeah.
wanted to share some recommendations, and and I think that was it. That was left. Yash, can you move to the next slide, maybe?
Yeah, so international. Okay, so I'll keep it very straight. International donors have now very specific queries for us. Rahul, is this project political or apolitical? Will this trigger government concerns or not? Rather, the conversation is along these lines. So if an international donor were to work on a skill development project versus rehabilitation of migrants, they would rather choose the former than the later. So that my response is self-explanatory now. International donors have now understood the sectors that they find comfortable working in for avoiding political risks or other risks. And a lot of times, international donors have now started to align their projects with the broader political projects that the government has, whether it be BJP or Congress or any other party. I am not going to take names because FCRA law is independent of who is in power. Any government that comes continues to weaponize this law. So it's a fallacy that I only speak about current government of the day and not about some other governments or previous regimes, right? I think most of the regimes that operate FCRA have continued to weaponize it and will continue to do so unless there is going to be some fundamental change in the way we look at the law. And foreign donors have now understood this dynamics, and they have largely repositioned themselves, and I know this because a lot of them happen to be my clients, so I can say this with a certain sense of authority and understanding. They have largely realigned themselves. They have. And those of them who have not been able to, they continue to be under the watch list. So yeah, so that's the impact on international donors. But yes, I think if we were still to be looking at the brighter side of things, as the saying goes, that there's always light at the end of the tunnel, but you never know if the light at the end of the tunnel comes from from a train that is coming to crush you, or is it just a natural light? So I see FCR in that sense. Increased restrictions on FCRA funds have now started to give some scope for blended finance and stock exchange models to come up. That's the only positive light I can see at the end of the tunnel, if at all it's a light even. But yes, international donors have now started to move from a pure philanthropy play to a more blended play. And this has largely happened because they have continued to face a lot of regulatory pressures through FCRA on their interactions with non-profits on the ground. And so the idea is to be more collaborative so that they are more ring-fenced, at a broader level. And when they are collaborative, then more often than not, issues that they will have to take up will have to be largely politically not so sensitive. so that these are the ways through which they believe they could be better ring fenced. Yeah. And these are not just the trends, these have started to take effect on the ground, take shape on the ground as well. And if you look at data or numbers, we find that if erstwhile there were more deployment towards human rights, now most of the deployments are towards non-core sectors, more on the lines of livelihood, skills, uh, and such non-thematic areas of concern. I'm not saying livelihood is not important. It is also an intrinsic, it is a part of human rights, but in terms of intricacies of how we traditionally see human rights areas to be, I think there has been a paradigm shift. Yes. Next slide, please. Recommendations. Okay, I'll read this out. Despite challenges, opportunities remain in India's non-profit sector due to expansive population, but operating strategies need to evolve to adapt to the changing regulatory landscape. This is another way to politely say that, guys, be a little smart about where you want to be and where you do not want to be. Yeah. Uh, Ensuring legal health is not a one-time endeavor, but an ongoing investment in your organization's future. Yes. One takeaway that I have is that a lot of times we do also see organizations being very stupidly lax on their compliance, and they have been. Like I have seen our clients as well who have not taken their accounting properly, who do not maintain their books properly, and that has led to some trouble. So I think at least on the compliance, the least we can do is to at least be good on paper. At least be frank on your transactions, be transparent with those things, and just do not treat your accounts department as an ad hoc department. If you are an FCI registered organization, your accounts guy or person is the most important guy. Let me tell you that. Because most of the sanctions or actions that the MHA is undertaking is basis discrepancies that they find in transactions or in terms of bookkeeping. Now, that may not necessarily be because of some ill doings that these NGOs do, but a lot of times because we do not invest so much in capacity building, we do not get that level of expertise or such smart talent, because there's a cap of 20%. So if we have a cap of 20%, we are not going to get Bill Gates come and work with us, right? So it's the cause and effects are quite correlated, but still, I think board members now will have to start taking a serious note of how the accounting looks like to be. While board members' mandate is to overall look at the broader objective of what the NGO wants to do and the impact it wants to create on the ground. But it's high time now that board members do get more hands-on with these transactional aspects and day-to-day challenges that your offices continue to face. If our board members are not cognizant of that, then probably we will continue to face more compliance challenges in the longer run, particularly from an accounting standpoint. Third, navigating FCRA's requirement while fulfilling their missions can be challenging for NPOs, but it's crucial for them to maintain their credibility and trust in the eyes of donors and public. This is a generic statement for all of you to feel good about the work that we do. That's all. But yeah, by carefully managing their compliance and financial resources, NPOs can continue their efforts to make a positive impact. This is again a generic statement. I have nothing more to add here. Comprehensive accounting practices, effective budgeting, and strategic cash flow management. Yes, I think this is one point where I think at least staffs should be trained to educate them on certain hygiene factors and certain triggers that FCRA has with respect to bookkeeping. And I keep harping on bookkeeping because more than 80% of action that is taken by the authorities against NGOs are invoked basis some discrepancies in filings or some facts or numbers that do not subscribe to the norms that are set out under the FCRA laws. And it may be inadvertently done by the personnels of NGOs, but I think NGOs should definitely invest more time and money into training this specific personnel. That is very important. And there's another point. The advice is to conduct audits, de-risk operations, and explore alternative structures and strategies to navigate the evolving landscape effectively. This essentially ties to my earlier point of be my earlier point of wanting to be more adaptive, where if you feel that FCRA contribution route was your only source of income, and now if that has dried up because your FCRA registration is in jeopardy, then be smart enough to look at blended finance, be smart enough to look at different alternative source of funding structures than become obsolete and die. So I think let's find opportunities in such adversarial situations is all I can say, because NGOs have been now trying to look at alternative sources of funding. And if my FCRA dries up, nothing stops me from raising debt from a foreign funder. I can always raise a debt through external commercial borrowing and I can repay it back. Why not do it? I mean, the problem is that NGOs also need to get out of their silos and look at explorative options. I mean, the worst that can happen is RBI say no to you. It's still better than MHA saying no to you, right? So yeah. So I think let us look at alternative options and let us hope that the ecosystem improves for the better. When it does, we do not know, but I do not see any improvement because the law is built on certain assumptions that are anti-democratic. Until the point we do not completely rehash the preamble and the central premise of the law, no matter which government is in power, let me tell you that this law will become more and more insane as we move along. That is the real issue here. Yeah.
Thank you so much, Rahul. I think I'm pretty sure everyone has appreciated your candor and your time most of all. This session went on for the exact duration that it was assigned for, and we're really grateful to you for fielding all the questions that came across. Rahul, I know you said you needed to leave. Is there anything else you want to close out with before you go?
No, I think I'm good. I think I have more or less expressed all of my points that I wanted to share with you folks. Should there be any specific queries, please feel free to reach out to me. Should I put my email ID here or will TRF team enable that?
So Rahul, I mean, we are happy to facilitate contact with
No
you.
problem. I leave it to
So
you
that,
guys to.
you're not overburdened with multiple emails on the same request or anything of that sort, unless
Sure.
you specifically want people to reach out. Okay.
No worries. I'll still just put out my email ID in case somebody feels more comfortable writing to me directly.
Perfect. Thank you. Thank you for doing that, Rahul.
Yes, and we'll be happy to answer any questions that your folks may have. And even otherwise, if there's any need for any discussion of FCRA or any help or strategy or advisory, whatever your folks need, please feel free to reach out to us and we'll be more than happy to assist in whatever way and form and manner we can. Thank you for having me, and it's been great to interact with you all.
Great. Yes, thank you so much, Rahul. We really appreciate your time. Yes, you can go to the next slide. I know everyone's had this, session as something that has been beneficial to all of you. Yes, this is just mentioning the different places Nishit Desai operates from. But of course, very strong presence here in India. Rahul's based in India as well, and has specific knowledge pertaining to the laws related to India, especially in the FCRA and blended finance as well as ESG sector. The next slide, please, Yash. So before everyone logs out, Rahul, of course, I mean, this portion is not so much for you, but more for the participants. We'd love to have your feedback. TrustLaw hosts a number of legal health checks for our members as well as partners members, like in this case. And we always bring on our legal members like Rahul to come in to speak about specific topics. So if you have any suggestions for us, please do reach out. Most of all, as we're wrapping up, I'd like to encourage you, please use the QR code to submit your feedback or use the link that has been shared in the chat. We noticed that not too many people completed the legal health check. which was shared earlier. So if you'd like to get in touch with us, you can also reach out to us. We'll be sharing our email addresses here in the chat. Please feel free to write to us at TrustLaw. Maybe Sean or Emmanuel, if you could just share the email addresses in the chat while people are completing the feedback form. And I'll also use this as a moment to thank everyone. We really hope that this session has been useful for one and all present here today. Rahul, thank you so much for your frankness and also for bringing so much clarity to the aspects of FCRA. I know a lot of questions came up and you've answered all of them with a lot of detail and clarity. I'm sure our teams will really benefit from, our members will really benefit from this. We like to build capacity of the civil society organizations, not just in India, but across the globe. And of course, our team that includes Emmanuel, Sean, and myself, we work specifically for Asia and the Pacific. So organizations based anywhere in this region can feel free to reach out to us and request pro bono assistance. As has been mentioned at the start of this session, we provide free pro bono assistance. We facilitate it through legal members across the globe, just like Nishit Desai and Associates. We provide assistance through advisory requests as well as research, and we really look forward to doing that for all of you who are present here and are eligible for our free membership. Please reach out to us and contact us. And most of all, thank you to the Pico Rise World Summit, as well as the Adobro team for giving us this opportunity. It has been an excellent one. We've had at one point of time almost 60 participants coming in on this call. And we really hope to stay in touch with all of you. So thank you very much. And thank you, Rahul, for staying right to the end.
Thank you for having me here. Thank you so much. It's lovely
Our
speaking
pleasure.
to you. Bye-bye.
Thank you. Yes, bye.
Thank you.